is Julie Ramsey, and welcome to Insurance Law. Key points in this section is expressed, implied, and apparent authority. And those are agent authorities, and we're going to dissect each one. Another acronym is CLOAC, C-L-O-A-C, and those are parts of a contract, and we'll go through each one of those parts. What makes insurance contracts different? So there's lots of definitions we're going to be going over. There's also some legal issues affecting insurance contracts, so some more definitions. What makes insurance unique? Let's get into the details. Agency law principles. First, let's talk about an agency. You see, an agent represents an insurance company, and they have what's created an agency. Several insurance companies have several agencies, and together they represent the one big home office, that insurance company. Now, the agent is also known as the producer. Agent and producer is the same thing, but they act on behalf of an insurance company. The insurance company is known as the principal. The agent is basically the sales rep for that principal for that insurance company. Agents are appointed by insurance companies. You know, you can't just decide, oh, I want to sell for this insurance company today. You have to be contracted. You have to be appointed with that insurance company before you can represent them. As we said, the principal is the insurance company. That's who the agent represents. The producer authority. We want to look at that actual contract because the producer has authorities. He's going to have a contract that he signs with that principal, with that insurance company. Now, in that contract, there are three kinds of authorities that I want to talk about. The first one is an expressed authority. If you think of that word expressed, it means written down. It's in the contract. And it says 1 through 200. This is what I can do. This is what I can't do as an agent with this company. But it's expressed. It's documented. It's in the contract. An implied authority. It's not written in the contract. It's not expressed. But powers are implied in order to do business. For example, let's say that you want business cards to do your job, and you get out the contract, and it never expresses that you can buy business cards. Well, it's implied. If you need that to do your job, then you can go and do that. The third authority is apparent authority, but it's what others assume the producer's authority is based on his actions or statements, because it's apparent. So I am speaking for the insurance company, and it's what other people, those clients, assume my power is. It's apparent. So expressed means it's in the contract, it's written down. Implied, it's not written in the contract, but it's implied that I have the powers, the authority to do that in order to do business. Lastly is apparent. Okay, it's what others assume my authority is based upon my action or my statements. So those are three authorities. A broker. A broker is an independent agent who represents the buyer instead of the insurance company. And a broker finds the buyer the best policy by comparison shopping. So when you see anything about a broker represents the client, the buyer, not the insurance company. And then he will find the best place in order to place that business for the client. Duties and responsibilities of the agent. As an agent or producer, it's the same thing. You have lots of responsibilities. One of those responsibilities is a fiduciary responsibility. Fiduciary means you're holding the money of someone else. It's not my money. I can't have the client make the check out to me, but I'm holding it for others. I'm holding it for the insurance company. So the agent has a fiduciary responsibility to the insured, the insurance company, the person applying for insurance, and all of his current clients. Now, to the insured, that agent must act in the insured's best interests and comply with all state laws. Evaluate the client's needs. This is what you have, this is what you currently want, and make some recommendations, lots of times known as a needs analysis. If the agent leaves a gap in coverage, the agent could be liable. It's very important that the producer sits down with that client and analyzes and documents, this is what they have, these are their goals, and I need to make some recommendations along the way. Now, to the insurance company, that agent must follow the agency contract. Remember, everything's expressed in that contract. It's written down. For example, I can't embezzle money as an agent. That money is the insurance company's, and I act as a fiduciary for that company. If the agent says something is covered, but it is not, in fact, the insurance company could be liable, all right? Because I represent the insurance company, right? So if I say, yes, this is covered, when in fact it's not, the insurance company will probably be held liable to pay that. They will have to pay. However, when they're done paying, they will come out and come after the agent in order to get compensated for that. Now, this next section is elements of a legal contract. And I want you to remember the acronym CLOAC, CLOAC. So make sure you spell it correctly, but always think of a coat or a cloak, CLOAC. Now, as we're looking at a contract, that C stands for competent parties. You have to be sane, sober, and of legal age. You may think sane and sober, but when you think of legal age, do you think of competent parties? I'm not looking for a number, but I'm thinking they have to be of legal age. The L stands for legal purpose. You can't buy insurance if it's not for a legal objective. All right? It has to be for a legal purpose. I want to spend some time, however, on this O and A, offer and acceptance, because sometimes there's some confusion here. You're going to have one person make the offer, the other the acceptance, but it's not always the same person. Let's say that you have an application with money. So the producer sits down with the client. You've got an application with money. Okay? The applicant, that potential client is making the offer. Why? Because they put money with it. They're serious about it. So it's a true offer. So that application with money then goes to the insurance company, and then the insurance company says, yeah, hey, you know what? We will accept this, and we will write this policy. Now, sometimes the insurance company won't accept the risk the way that application is written. And instead, they'll have what's called a counter offer, where the applicant made the offer, but the insurance company says, well, you know what? We're going to counter that offer, called a counter offer. And the insurance company will rate up the premium. Why? Because it's a greater risk than what was initially stated on that application. All right? And then the applicant can decide, gosh, do I want to accept this or not? Now let's look at another situation. Let's say that we're sitting down with a client and that agent gets an application, but there's no premium, no money with that application. Well, we said in order to have an offer, you have to have money with that application. So it's not a true offer because there's no money with that app. So the applicant makes an invitation to make an offer. It's not a true offer. There's no money. In this example, the insurance company makes the offer. And then the agent will present that to the client, and then the applicant accepts. How do they accept? By paying the premiums. You always have to have money with it. Now that last C stands for consideration. Anytime you see the word consideration, always think money, all right? Money means consideration. The insured promises to pay premiums. Not only that, statements made on the application are true to the best of their knowledge. So what is the insured's consideration? It's premiums and statements made on the app. The insurance company promises to pay the policy benefits in the event of loss. Make sure that you're very comfortable with that acronym CLOAC, and then you know what each one of those terms, what those mean. Now I want to spend some time on what makes insurance contracts unique. What makes them different? The first definition that I want to talk about is a unilateral contract. It's an exchange of an act for a promise. And when you look at that word uni, okay, that's a Latin term that means one. Only the insurance company is legally bound to do anything once a policy is in force. Well, what does that mean? What that means is if, let's say that the insured doesn't pay his premiums, all right? The insurance company can't go back to that insured and say, well, we're going to sue you because you're bound, you have to pay. Instead, the insurance company will just cancel the policy. They can't go after the insured. But however, let's say the insurance company doesn't pay the claim when they're supposed to, all right? If that happens, then you better believe, I'm sure the insured will come after the insurance company. Why? Because they're legally bound. Another term I want to talk about is contract of adhesion. Contract of adhesion, I want you to think of glue. Either you want it or you don't. It's not like real estate where you can go back and forth, change the contract. I want this or that, whatever. I can't do that. Client, either you want it or you don't. It's like glue. I can't change the way it's written. Either you want it or you don't. Now, if you've ever read an insurance contract, there's all types of technical and legal language that's in that contract. And a lot of times the client will have a dispute and say, well, gosh, I had no idea that this is what it meant. Or the way I interpret it, I thought it meant this. The insurance company might say, well, no, that's not what we meant at all. It means this. The client could have a legal ambiguity and say, hey, I disagree. The way it's stated, I think it means this. A court could get involved. And if that does happen, the courts typically do fine for the client. Why? Because it's a contract of adhesion. Either you want it or you don't. It's like glue. The client had no input into the way it was written. So when you see contract of adhesion, think of glue. Either you want it or you don't. Take it or leave it. Another definition is aleatory contract. You see, insurance is an aleatory contract. It's an unequal exchange between the parties. When you think about it, one party pays a small amount in relationship to the other party that pays a large amount. Typically, the small amount is, the insured is paying their premiums. And then when there's a loss, the insurance company pays out a huge amount. But it could really be the opposite way. Say that you have an insured who pays premiums and premiums and premiums for years and years and years, and they never have a claim. That's very possible. The insurance company may pay out a small amount or nothing, and the insured is paying out a large amount. So aleatory contract, what does it mean? It's an unequal exchange of value between the parties. Insurance is a conditional contract. When you see the word conditional, it just means rules. And as you're reading the contract, there are a lot of ground rules in that contract and how it works. Personal contract. Most insurance contracts are personal contracts. It's a personal agreement between the insured and the insurance company, and ownership cannot be changed. Why? Because it's a personal contract. However, life insurance is not a personal contract. Why isn't life insurance a personal contract? Because ownership can be changed. You can change the ownership in life insurance. Now, there are some legal issues affecting insurance contracts. Reasonable expectations. What do you expect the coverage to do? For example, if you go buy a brand new car, you expect on that new car to have brand new tires, right? Reasonable expectations. What would this client expect this coverage to do? Utmost good faith. That means you should be able to trust your insurance agent. And your state law probably has things like the agent must not have convicted any felony or must not be in trouble with the law at all, because we're going to hold that person up on a pedestal. It's an industry of trust. Representations. Representations means it's true to the best of my knowledge, all right? And when you're taking an application on a client, you're going to ask questions like, when's the last time you've gone to the doctor? A lot of times that client will not know specifically as to when it was. They didn't mean to lie, but maybe they were off a few days, a month, whatever, but they're saying this is true to the best of my knowledge. Now, unless they meant to lie, it can't void a policy. However, if a misrepresentation is material means had we known this information, it would have totally changed the underwriting decision. If that's the case, it can void the policy. Had we known this material information, had we known you had cancer, had we known you had a claim last year on your homeowner's policy, we wouldn't have wrote the policy because it was substantial. It was material information. Concealment. Now, concealment is the intentional withholding of known information. Concealment means I'm not going to tell. I'm going to conceal this information and I'm not going to tell. If the insurance company, they might be able to void the policy if they can prove that you intentionally concealed this material information. So concealment is, hey, I didn't lie about it. Instead, I just didn't tell you. Fraud is when someone intentionally lies. They flat out lie about something. A warranty. Statements considered to be guaranteed to be true. If it's a warranty, it's guaranteed to be true. Waiver and estoppel. It's really hard to explain one unless you're explaining both of them. They go hand in hand. A waiver is the voluntary relinquishment of a known right. For example, let's say the insurance company says, hey, you know what? This is what the contract says, but you know what? Forget it. We're just going to go ahead. We're going to accept this the way it is. No problem. Waiver. Let's say that you get an application and you're spending time with the client and you don't fill out all the blanks on that application. Say you forgot their middle name, whatever. It was something small. You send that to the underwriters, and the underwriters at that insurance company say, you know what, waiver, forget it. We don't need to know that. No big deal. We'll go ahead and issue it anyway. Waiver, we're going to be nice. Estoppel. Now, estoppel is preventing the reinsertion of that known right or privilege that was previously waived. Estoppel means you can't come back on that thing that you waived, right? And then change the rules. So we could never deny a claim because Joe Client forgot to put his middle name. Why? Because we waived it. So waiver means we're going to be nice. We're going to waive it. Estoppel means we will continue to be nice. We won't change the game rules later on in play. So waiver and estoppel. To recap in this section, we talked about expressed, implied, and apparent. And those are agent authorities. Express means it's written down in the contract. It's what I can or cannot do as an agent with the company. Implied means it's not specifically expressed in that contract, but it's implied I have the authority to do that in order to do my job, like buying business cards. Apparent authority. It's what other people assume my authority is as an agent with the company. We talked about the parts of a contract, and the acronym we're going to learn is CLOAC, C-L-O-A-C. So I always think of that cloak I'm putting on. What makes insurance contracts different? There's a lot of definitions in this section, and we also talked about the legal issues affecting insurance contracts. So make sure you spend time on those definitions. Thanks for joining me today at Insurance Law.